According to the most recent data, there are more than 9 million seniors in this country currently eligible for property tax relief. But here is the number that should haunt you. Only about 8% of them actually apply. That means an estimated 92% of eligible seniors are overpaying their property taxes, leaving hundreds, sometimes thousands of dollars on the table every single year. Most homeowners believe that because the government has their birth date on file or their veteran status in a computer somewhere, their senior discount will just kick in automatically once they hit 65. That is a legal myth. In almost every single jurisdiction in the United States, property tax assistance is not automatic. The law requires you to raise your hand and ask for it. If you don't file the specific paperwork required by your county, the government will simply continue to bill you at the standard rate, legally pocketing money that the law says should stay in your pocket. By the end of this video, you'll know exactly which 3 legal mechanisms protect your home, why the system is designed to stay silent, and the specific 2026 law changes that might have just made you eligible even if you were denied last year. The core of the problem is a massive bureaucratic disconnect. Your local tax office is a heavy machine. While the DMV or the Social Security Administration might know exactly how old you are, those systems rarely talk to the property tax assessment system. Legally, the burden is on the homeowner to bridge that gap. This is especially true for veterans. Many assume the VA handles their tax status, but the VA does not notify your local tax assessor of your disability rating. You have to provide the evidence, like your DD-214 or a disability rating letter, directly to the county. When we talk about senior property tax relief, the law generally uses 4 different tools to lower your bill, and in many states, you can stack them for maximum savings. The first is the Homestead Exemption. This is the most common form of relief. It doesn't change your tax rate, but it legally reduces the taxable value of your home. Think of it like a standard deduction on your income taxes. For example, in Texas, the state requires school districts to provide a $140,000 homestead exemption for all residents. But if you are 65 or older, the law mandates an additional $60,000 exemption. That means the first $200,000 of your home's value is effectively invisible to school tax collectors. But here is the curiosity gap most people miss. Exemptions are rarely retroactive. If you turned 65 3 years ago and just realized you qualify today in most states, that money from the last 3 years is gone forever. You generally cannot go back and ask for a refund for years you didn't apply. However, there are rare exceptions. Texas, for instance, allows you to file for an over 65 exemption up to 2 years after the delinquency date. But for the rest of the country, every year you delay is a permanent financial loss. The second tool is the assessment freeze. This is arguably the most powerful legal protection for seniors living in hot real estate markets. While a homestead exemption takes a flat dollar amount off your value, a freeze locks your home's assessed value in place. Even if the house next door sells for double what you paid and the market value of your entire neighborhood skyrockets, your tax bill stays anchored to the value of the year you qualified. We are seeing a major legal shift here in 2026. In Illinois, for example, the governor recently signed Public Act 104-0452. Senate Bill 642. This law significantly expanded the Senior Citizen Assessment Freeze Homestead Exemption by raising the maximum household income limit to $75,000. If you live in Illinois and were told previously that you made too much money to freeze your taxes, that may no longer be true under this new 2026 standard. The third tool is what the law calls a circuit breaker program. Just like an electrical circuit breaker prevents a house from being overloaded with power, these laws prevent a senior from being overloaded with taxes relative to their income. There are currently 18 states using these programs. If your property tax bill exceeds a certain percentage of your yearly income, say 3% or 4%, the state government will actually issue you a refund or a credit to cover the difference. In states like Maine and Maryland, this even applies to renters. The law recognizes that landlords pass property taxes down to tenants through rent, so low-income senior renters can often claim a portion of their rent as property tax paid and get a check back from the state. If you're a senior who sold your home and moved into an apartment, you might think your property tax days are over, but you could legally be leaving a state refund check on the table. The fourth tool is tax deferral, but this comes with a heavy legal warning. A deferral doesn't eliminate the tax, it simply postpones it. The state or county pays your taxes for you now, but they record a lien against your property. That money, usually plus interest, must be paid back when the home is sold or when the owner passes away. While this provides immediate cash flow for house-rich, cash-poor seniors, it effectively draws down the equity in the home, meaning your heirs will inherit a smaller estate. The most dangerous legal trap in this entire system is the assessment notice. This is that modest-looking card that arrives in the mail once a year showing your property's assessed value. Most people sigh and put it in a drawer. Don't do that. That notice is your window to protest. Assessors make mistakes. They might think you have a finished basement you don't have, or they might be comparing your modest home to a mansion down the street. If you don't protest an overvalued assessment within the strictly enforced legal window, which can be as short as 30 days, that valuation becomes final, and you are legally obligated to pay taxes on that phantom value, even if you have a senior exemption. As we move through 2026, keep an eye on Texas. Lawmakers there are pursuing a proposal known as Operation Double Nickel. If enacted, this would lower the age for certain school tax freezes from 65 down to 55. This reflects a growing trend across the country, recognizing that the tax squeeze starts well before retirement for many Americans. To protect yourself, you need to take 3 steps. First, call your local county assessor and ask exactly which exemptions are currently attached to your account. Second, specifically ask if your county offers an assessment freeze and what the income limit is. Remember, those limits are rising in many states this year. Third, mark your calendar for the recertification deadline. Many of these programs are not set it and forget it. If the program is income-based, the law often requires a simple annual affidavit to prove you still qualify. Miss that one piece of mail, and your taxes could jump back to the full rate overnight. Thanks for watching the legal lecture. If you found this helpful, subscribe for a new video every week and leave any questions in the comments. See you next time.